Welcome back to Good Law, Bad Law. My guest this week is retired Superior Court judge in California, LaDoris Cordell. Judge Cordell was one of the leading voices opposing the recall of Judge Aaron Persky in California last week. He was recalled for the sentencing, for his handling of the sentencing in the Brock Turner sexual assault case. And if you think that this issue is clear-cut, you need to listen to this episode. We're going to talk about the Me Too movement. We're going to talk about criminal justice, sentencing, what it means to recall a judge, and why, according to Judge Cordell, what happened in California with the recall of this judge is a tremendous threat to the independence of our judiciary. Stay tuned. It's a great episode. My guest today is Judge LaDoris Cordell. Judge Cordell, thank you so much for being on the program.
Thank you for asking me to be here.
And for being here in person. It's a pleasure to meet you in person and have you in the studio here in Philadelphia. You come here from Santa Clara County, from California, and fresh from the battle over the recall of Judge Aaron Persky. And we're going to talk about that, what led to the recall. This is a national story now with huge implications beyond Santa Clara County and beyond California, and we're going to talk about that as well. But before we get into the details of the story, Judge, give us a little bit of background on yourself, your years on the court, and then how you got involved in this very important and far-reaching battle.
Sure. First of all, I grew up on the East Coast here in Ardmore, which is just a few miles out from Philadelphia. I ended up going to law school at Stanford and stayed in California because the weather is terrific.
It is terrific out there.
So I practiced law there. At one point, I was the assistant dean of the law school at Stanford. I did that for a few years, and then was appointed by Governor Jerry Brown to the bench, and that was in 1982. So I served on the Superior Court of Santa Clara County, and that is the trial court in the county, for 19 years. I retired from the bench in 2001 and became the vice provost of Stanford University and special counselor to the president. So I wasn't just at the law school. This was overall at the university, and it was primarily an administrative position I held for 8 years. And thereafter, I was appointed the Independent Police Auditor for the city of San Jose. And I did that job for 5 years and retired in 2015. So right after that, then I was retired. I've done some volunteer work in the legal system, but then really kind of planned on kicking back a little bit and reflecting on my years in the legal profession until this recall happened. And I ended up becoming perhaps the most vocal voice of the opposition to the recall of Judge Persky.
So supporting Judge Persky staying on the bench.
Correct.
Okay. So we have to set the scene here. We have to go back in time a little bit, not that far back, to understand why this issue became so inflamed and so polarized, and why, for the first time since 1932, a judge has been recalled in California. And I think since the 1970s that this extraordinary step has happened anywhere in the country. And to do that, we have to talk and understand the basic facts of the Brock Turner case. So why don't you give us a bit of a synopsis of what happened there?
Sure. And for anyone who has questions about my description of the case, I always say to people, this is what we learned in law school, right? Go to the source, go to the rule. So the source is the transcript, the probation report, the transcript of the trial. All of that's online. So if anybody has any questions about what I'm saying, you can confirm that I'm speaking the truth and that everything is out there. So very briefly, in 2015, December, and I hope I'm getting my dates right, if not, it was January 2016, there was an incident on the Stanford campus where Brock Turner, at the time a freshman, 19 years old, and he was basically a budding Olympic swimmer, went to a frat party, and there was a lot of drinking, and this was on the Stanford campus. Also at the frat party was a young woman who was a few years older than Brock Turner, who was not a Stanford student or a Stanford graduate. She was a college graduate, and she came to the party. She came to the party already having consumed a lot of alcohol and consumed more there, as everybody else was doing. Brock and this young woman, whom has become known as Emily Doe, did not know each other prior to that interaction. They ended up hooking up, making out, and then eventually ended up outside the frat house. And she ends up slipping. She's on the ground. He gets down on the ground. They're both very, very intoxicated. And according to the testimony of Brock Turner at the trial, and there's no other witnesses because this young woman was blacked out from the time she got to the frat party. And by blacked out means you've consumed so much alcohol that you're drunk, but you're not passed out unconscious. Blacked out means you just have no memory of what it is you're doing. So there may be indications that you're drunk, you may be slurring your words, but you're still functioning. So outside on the ground, according to the testimony, and again, there's only one witness to this who remembers anything, and that's Brock Turner. He said, "May I finger you?" And she said, "Yeah," in which case her underwear was taken off by him or her or both. And he fingered her. And during that time, it appears that she passed out and became unconscious. Two graduate students at Stanford were passing by, did not know what was going on, but what they saw was a woman lying, not moving. She was absolutely unconscious at the time with Brock Turner on top of her. And it's important to know that he never had his pants down, never had them unzipped. They approach him. He gets up to run. They're yelling at him. They catch him and they hold him down on the ground until the police arrive. The young woman, Emily Doe, is then taken to the emergency room, and she doesn't come to for several hours. Yeah. And there's an exam which shows that there was no semen in her because, as I said, he never had his pants down. But they did find DNA on his fingers, just as he said he did to her. So he was eventually charged by the district attorney of Santa Clara County with 3 felonies. The first felony being the most serious, which is assault with intent to commit rape of an unconscious person or an intoxicated person who is too intoxicated to prevent the assault. And the assault was the digital penetration. And then 2 other felonies, one of which was digital penetration of an unconscious person, and the other digital penetration of an intoxicated person who could not prevent the digital penetration. So the major one was the first one I just described to you.
Those second 2 sound like really subsets of the first.
Correct. But they were 3 felonies. He was convicted by a jury, and then he came for sentencing in June 2016 before Judge Aaron Persky, who presided over this trial. And it was what Judge Persky said that led to this recall and his eventual removal from the bench. The word he said that triggered the outrage was jail. If he had said prison, he would have been touted as one of the best judges on the planet. He didn't. He said jail. And why did he say jail?
What's the distinction here?
So first of all, and it's an important distinction because some people confuse them and use the words interchangeably, and they're not interchangeable. So a jail is a local facility. Most cities have a jail, and that's where it's nearby, right in the city, and it's usually help for people who are not going to be incarcerated for a long time, up to a year, generally. And then you have prisons, of which California has many, many, and they are located out in the boondocks. They're away because people don't want to be living near prisons, and that's generally where people serve more than a year. It could be a life sentence, could be death penalty, serving a death sentence until they're executed, obviously, or years.
And necessarily prison would also be for the more serious criminal offenders.
Absolutely.
Because they're serving the longer sentence.
Exactly.
Okay.
And so one is placed on parole if they get out of prison, and if one goes to jail, this is again California, they're placed on probation for a certain period of time. So after the conviction of Brock Turner, his case was referred to the probation department. In California, anyone who's convicted of felonies, unless both sides say, no, we don't need a probation report, these cases get sent to the probation department. And then they're assigned a probation officer, in this case, a woman who is the more senior person in the probation department, was assigned the case. She then puts together what's really a pre-sentence report, and it's to guide the judge. It's given to the district attorney, it's given to the defense attorney, and it's available to the public for a period of 60 days. Then that probation report is sealed. That being said, the probation report can be found online today if anyone wants to read it. And actually, it's a very good read. So the job of the probation officer is to interview the victim, if the victim will talk, and in this case she did. Mm-hmm. And she basically said to the probation officer, I don't want him to go to prison. I don't want to ruin his life. I mean, he did a bad thing, but he's not a bad person. Those kinds of things. That's all in the probation report. And then she interviewed the defendant, Brock Turner. Defendants don't have to talk either, but in this case he did, and he expressed his remorse for having done, and he said something like, every day, I think about what I did and about this case, and then gathered information from others, character witnesses, if people wanted to submit letters. She did a review of the police reports, so it's all summarized. It's kind of standard in these pre-sentence reports, and then it was given, this whole packet was given to Judge Persky, the DA, and then the defense attorney. There was then a sentencing hearing. And that's where, I was a judge for 19 years, and I handled just about every kind of case, but spent a lot of time handling criminal cases. And it is the most difficult aspect of our work is sentencing, because we have to consider a number of factors in California. It's something called the rules of court. And there are about 17 factors that we are required to look at and consider when we choose what sentence we want to impose. The probation officer, and I stress again, a woman who spoke to everybody, recommended that Brock Turner be granted probation and be sentenced to jail for 6 months. That was her recommendation. And because of the nature of these offenses, he has to register as a sex offender for the rest of his life. For most people,
what does that mean? I mean, what's involved?
Yeah, and I appreciate you asking that, because most people don't kind of get what that means. Basically, what it means is that you can now be lawfully discriminated against for the rest of your life in housing and in employment. You can only live in certain places that maybe, not near preschool, near children. You can be discriminated against in employment. People can decline to hire you, or you can't work where they're young people or kids. Maybe you can't be near a college campus. And that's the rest of his life. And think about that, somebody who committed this offense when he was 19 years old. So now he's maybe 21, 22, and this is the scarlet letter. And anyone who Googles his name, anybody who goes on the sex offender registry, his name will pop up, and that's for the rest of his life.
He also left Stanford, right?
He was kicked out. He was expelled. It wasn't like he expelled, and that was a budding career. He was basically looking to swim in the Olympics. It's not going to happen. So that was the recommendation of the probation officer, Judge Persky, after hearing from the victim. And it's interesting, the victim did a 180. When she got to court, she read a statement that has been read by Joe Biden on the floor of on the House of Representatives or the Senate floor. And the statement has just gone viral, where she's now throw the book at him, he should be punished. She did a 180. And, there's a question out there as to why that happened. Why did she do that? I have my own theory, and we can talk about that in a bit.
Well, I have at least part of what she said here, and not to go into the whole thing, but as you point out, the probation officers or officials' recommendation was a year or less than 6 months specifically. And what she said at trial in part was, quote, I told the probation officer I do not want Brock to rot away in prison. I did not say he does not deserve to be behind bars. The probation officer's recommendation of a year or less in county jail is a soft timeout, a mockery of the seriousness of his assaults, an insult to me and all women.
Right. But that differed from what she told the probation officer, who spoke to her for about an hour. So, and it's fine. The victim has every right to change his or her mind when they come into court. But I want to stress on the rules of court and things that we have to consider. What the victim wants is not determinative of what we judges must do. And a lot of people don't understand that and think, well, why not? Why are you considering the circumstances surrounding the defendant? Because that's what the law requires. And it should be, because we have to look at all these factors. If we were just victims' rights advocates, we would be throwing the book at everybody, because that's what generally victims want. That's not what we judges are to do. So Judge Persky followed the recommendation of the probation officer, and in doing so, he stated all of his reasons on the record, and at the trial, the sentencing transcript is online. People can read it, and at sentencing, Brock Turner again expressed his remorse.
Judge, let me interrupt just for a second, because you've focused so far on the recommendations of the probation officer. There are other recommendations that Judge Persky and that any judge would consider in this kind of situation, including the defense attorney's recommendation and the prosecutor's recommendation. And as I understand it, the defense asked for 4 months and the prosecutor asked for 6 years. These felonies that he was convicted of carry a maximum of 14 years. So I just want to get that out there.
Absolutely.
Because those are
Sure.
also, aren't they, things that the judge has to weigh and,
Absolutely.
and figure out. In other words, it's not like there's one answer. If you commit this crime, this is your sentence. The judge has to weigh all of those and consider all the factors that reach what that judge considers to be a fair sentence.
Exactly.
Okay.
And so, and I appreciate your clarifying all of that, because the judge could have said, I find X, Y, and Z from the rules of court guidelines, and say, and I'm sending you away for 14 years. Could have
done
but
it.
did not do that. And I think he would have, in my view, would have abused his discretion. In my view, this wasn't even a prison case. This was not a prison case, because if we look at the factors we're to consider, yes, I know what the victim said and I know what the victim wanted. That's part of it, but that's not determinative. So what we look at is prior criminal record. None for Brock Turner. We look at his age. Well, he was 19 years old when he committed the offense. So the youth. We look at, was this a crime of sophistication? Meaning, was there planning? Was he lying in wait? None of that. These were 2 intoxicated individuals. So when you consider these factors, this was not a prison case. Brock Turner did not deserve to be at San Quentin or for 6 years. And I really believe the district attorney's recommendation of 6 years was disingenuous. I think because this case had become so high profile
Right.
that the DA was, in my view, pandering to the kind of the public outcry that had been, I think, really spurred on by the media and the media's mischaracterization of this case and who Judge Persky is. And I think they were pandering.
Well, this case really comes at the front end of what we now call the Me Too movement, and there have been other, I say celebrated, not in praising terms, but because they became very publicly known, widely known publicly cases. The Bill Cosby trial was right here, right outside of Philadelphia very recently. Other celebrities, whether chefs, politicians, people in the news media, you name it, their cases have become perhaps more known and more talked about and more significant in a certain way than otherwise they would have.
But when you think about it, but Brock Turner was not a celebrity.
No, right.
I hadn't even heard of Brock Turner. This case started out, the recall claim and the yelling about this case was well before Me Too. So it happened that the perfect storm for those who wanted the recall happened with Harvey Weinstein. So when that case jumped up, it was those pushing the recall, and specifically the mastermind of the recall, a Stanford law professor, Michelle Dauber, decided and basically co-opted the Me Too movement. This case had nothing to do with Me Too, in my view. Absolutely nothing. But she got people all excited about it and whipped them up as part of it. So no one ever heard of Brock Turner. And had no one said anything, he would have, his life was still ruined. He had to register as a sex offender. Stanford didn't want him anymore. But it really just took on a whole different level of it, got a different level of attention because I believe, the confluence of circumstances that happened in this country.
Well, so go back to something you started to say before when you said that Judge Persky's great sin in the sentencing is he used the word jail and not prison. Because now we understand a bit more about what a judge is supposed to do and when they're arriving at a sentence and all the, well, at least some of the crucial factors that they would consider. Why was that a sin that he mentioned the word jail rather than prison?
So in my view, it wasn't a sin at all. What he did was absolutely appropriate, but he didn't say the P word, he said the J word. Yeah. So in this case, it was Michelle Dauber, who was sitting in the courtroom, who had whipped up attention about this case just as a result of the charge being made and then all through the trial. And so it was, the outrage was he should have gone to prison. And I think at this point she wanted him to be sentenced to 2 years in prison. And Judge Persky did not look around the courtroom and look at all the angry faces and say, oh, I better do what these angry people want. Instead, he focused like a laser on the law and the facts. He did not abuse his discretion. And the reason I say that with certainty is that neither side appealed his decision because there was no abuse of discretion. Had he done something wrong, it would have been appealed and it would have been reversed.
And if
Never happened.
And if you're a judge trying to weigh these factors and you go with the recommendation of the probation officer, does that almost, as lawyers might say, prima facie, on its face, suggest that the sentence is reasonable?
And that's a very good point, and my answer to you is yes. Probation officers are not going to recommend sentences that are unlawful. So this judge did nothing unlawful. He upset a whole lot of people who felt that the sentence should be harsher. And everyone has every right to feel that way. I've been in the same situation when I was on the bench. I had a 15-year-old Latina who was convicted because in juvenile court there's no jury in California. So
it goes to a judge.
I convicted her of felony murder, and I did not send her away for years and years. Instead, I gave her a year in a facility, plus everything else that went with it, and there was all this outcry. But fortunately for me, it was before the big social media was really there, so that the newspapers headlines, "Judge gives murderer a year." I had every good reason for doing what I did, and it turns out in the end I did the right thing, and she has done very well. So he did not abuse his discretion, but we are supposed to, in sentencing, use our discretion. That's what sentencing is all about. If not, then we just put computers on the bench, plug in the offense, and spit out what the sentence should be. So what is an interesting offshoot, the whole recall thing, is that the law's been changed in California.
As a result of this
As
case.
a result of the direct result of the recall, so that now there is no judicial discretion permitted. If anyone else commits the offenses that Brock Turner committed, that person must go to prison for a minimum of 3 years. So that means the next 19-year-old, first time away from school, goes to a frat party, good kid, gets drunk, it doesn't go well with say a young woman, and drunk or not, and he gets convicted, this person who maybe, as I just said, first time away from home, he's going to San Quentin or Folsom or Soledad for 3 years. I think that is outrageous. I think this whole recall, this is one part of the bad result of the recall, is taking us back to the mandatory minimum sentencings, which resulted in mass incarceration in California.
Yeah, we have to talk about that
right?
some. Yeah.
So that's one outcome.
But let me clarify a little bit here. The recall itself, the vote was just last week. We're recording, and our episode will be posted this Friday. The vote itself was last Tuesday,
June 5th.
June 5th. And what you're referring to is the California legislature passing mandatory minimum sentences for the felonies that Brock Turner was convicted of. That new law in California, that was before the vote last week, right?
That's correct.
Oh,
So it was early on in the recall.
Okay.
So the recall's going, the legislature, I've never seen a bill go so fast through the legislature in my life. And it was stunning to me and very upsetting to me that everyone was so willing to just jump on the bandwagon and, yeah, we can't let judges have discretion with these offenses. And it's very sad because you wait till the next this happens again, and it probably will, sadly, and it be the child of someone who's very famous or high profile. And if that young man, gets convicted, he's going to San Quentin.
Well, and we need to really explore that further. This, mandatory minimums, mass incarceration, the impact on entire communities in our country, and whether we're really accomplishing what we think we want to accomplish through the criminal justice system by being, quote, tougher on crime. But before we get into all that,
Sure.
I wonder the place of this case. There is an outrage factor when something like this happens, and I want to get your sense, and I want to come back to what happened to Judge Persky, because I know your view is he's a victim in this in this whole process, and that to some extent Brock Turner is as well. But this is a type of crime that historically has seen all kinds of patterns of practice in our criminal justice system that have created a sense of outrage today. You have women, it's mostly women we're talking about, who are victims of sexual assault and rape, who are demeaned, who are not believed, who as a result are often discouraged from coming forward by the system. People who are accused of these crimes who turn on the victim and blame the victim, and when they are punished, are often punished in a very light-handed way. This was some would say, and looking at him, a very privileged young man at a fine and expensive university, an athlete, and these are people who, in the popular sense of these situations, often get off lightly. Is there something to that, and is there a basis for outrage? We're not talking about a 19-year-old who was found with a joint in his pocket and ends up going to jail. This is someone who was convicted of felony sexual assault.
To pick up on the very last thing you said, this isn't a 19-year-old who had some weed and then
Right.
whatever. Just know there are lots of 19-year-olds, 20-year-olds, young black men who have been sent to prison for long periods of time for possession of marijuana and other drugs, and nobody has been screaming and hollering about them. So let me just lay that aside now. So
and for a lot longer than he went.
Right. So let's just talk about our criminal justice system is broken, and I'm just going to talk about California. It is broken. I have all my life in the law been working to improve, change the criminal justice system. So I'm one of those who's been fighting long before any of this stuff, the recall, even came along. So I am the first to acknowledge there are so many problems in our system, including the way the criminal justice system has treated women. And I don't care what color, and I happen to be African American, there is a major, major problem. So given that, you do not fix a criminal justice system that is broken with an emotional appeal to people and ending up with a recall. You fix it with serious and thoughtful reform. This recall is none of that. So as we move along, what is going to change in our criminal justice system in California, and maybe as you pointed out, around the country, is that judges are going to now hesitate before mixing punishment with compassion, with mercy. Because no judge has ever been on the recall radar screen for imposing a harsh sentence, ever. There's been no outcry when young people have been sent away for years as children, juveniles, and given life sentences. Oh, no recall issue. So judges are going to look at this and say, oh my goodness. So if I do what I really want to do, what the law says I should do and what my heart says, I'm not going to do that because that's going to be perceived as lenient. So what we're going to see are harsher sentences coming out from judges who are fearful of the electorate saying, oh, you're not being tough enough. And it's especially going to show its face in sexual assault cases.
But what if one possible outcome of this, and we have to, again, and we will talk about the broader issue of mandatory minimums, perception of toughness on crime, and what this is doing in terms of mass incarceration as a country. Can we tolerate millions of Americans, huge percentages of whom are minorities, racial minorities, for nonviolent crimes? Can we tolerate that as a people and as a country? But this isn't one of those cases. This is a case of sexual assault, which again historically has not seen offenders serving real time, and particularly, again, I say in the perhaps popular perception, whether it's the football players or the future Olympic athletes, are they getting off easy? Where the victims she has to live with this for her whole life. She's not a sex offender; she's a sex victim. Sexual crime victim for the rest of her life. So is there a way in which this can be separated out from the bigger issues that we face as a country, and in California, particularly in terms of crime and punishment, because what we are talking about here is a sexual assault crime.
So,
What's wrong with that?
Well,
What's wrong with being tougher on this kind of crime, I guess is the question.
it's not the issue about being tougher. It's about taking women seriously in our courts, and that up to several years ago has not been the case. It's changing because we're getting more women on the bench. We're getting more women in positions in probation officers and as district attorneys, as defense attorneys. So things are changing, and yet we have a way to go. To make an example of this case and saying, well, this is a judge who took an athlete, a white guy, and he's an athlete. And when you say privileged, I'm not even sure what you mean by that with respect to Brock Turner. He's not some rich kid. He's not. He happens to be white. And yes, he went to Stanford, as a lot of folks did. I did. And he was going to be on track to swim in the Olympics. All right. So the question is, did Judge Persky, just give him that sentence because he was a white male and he was at Stanford? And the answer I can give you definitively and factually is no, because this is a judge who has a history of basically saying, especially to young people and young people of color, I don't want you to get chewed up in this criminal justice system. I'm going to give you an opportunity to get your act together. And I can say that because I can give you specific cases. That was his reputation. So now we no longer have a judge on the bench who will look at young people of whatever color and say, I'm just not going to throw away the key on you because you are black or Latino. That's not what I'm going to do here.
That has not been talked about at all in
Well,
this
and
judge.
I can give you specifics. And one in particular that is just so, well, there were a lot of cases that he handled. He presided over 2,000 criminal cases. The recall people pulled out 5 and said, look, this shows he has a bias in favor of white athletes and a bias against, defendants of color. And those cases show just the opposite. And that's why I say this recall campaign was the most dishonest campaign I have ever encountered.
Without getting too deep into the personalities here, because every political battle is going to have its personalities. I mean, unless you want to, Judge. But what do you think? There are times in history, there are moments in constitutional history, there are moments in criminal justice history, as the law evolves, as a people we evolve, where someone or some issue is made to represent something far more than what it is. And this case has been marked in that way from the beginning, for sure, for good and for bad, depending on what you think of it all. But we know that there are times when juries send a message. In fact, most trial lawyers, and I'm one, has tried many cases and have many times said to a jury, send a message, in this case, about such and such. This is a different point in time in history as far as how sexual crimes, men and women, how they relate in society and how the legal system treats those relationships, where there's a lot of change happening. It's happening quickly and it's happening in very big and significant ways. What is wrong with, in this case, even if Judge Persky himself, or even if Brock Turner himself is made an example of, if this sends a message that reverberates in some positive ways, well, what would be? I'm playing devil's advocate here.
No, it's fine.
What is wrong with that?
Well,
if he's made an example of, and if Brock Turner's made an example of, if the net of that, if one of the results of that is, we're going to take these types of crimes far more seriously than we ever have.
You're being very optimistic and hopeful, because that's not what's going to happen and what's happening now. What's happening now is, one, we got mandatory minimum sentencing, which is taking us backwards. We are getting, the result is, if you're saying take seriously, that's code for throw the book at them.
Punish more stiffly.
That's what you're saying. And if we want to do that, then let's just have mandatory minimum sentencing for all sexual assault crimes. Let's just send everybody who gets convicted Whatever the levels are, just send them all off, give them the harshest punishment. No, I'm just saying that's an outcome, and that's not a good outcome. You know, there's a reason, at least in California, we don't leave sentencing up to juries. We do not. Some states do. In Texas, I think maybe they do something like that. I don't know. But in California, we don't do that. And in fact, what we instruct jurors, and you know this very well as a trial attorney even here, one of the basic instructions is when we give the case to the jury, we say, you are not to consider public opinion. You are not to listen to the radio or TV about this case. You are to focus on the law and the facts. We demand that of our jurors. And we demand that of our judges. The same thing. You're not to look around and say, oh, okay, let's make an example of Brock Turner. No, you look at this young man, you look at the circumstances surrounding the crime, and then you impose a punishment that fits the crime and all of the circumstances surrounding who that young man is. You consider what the victim has gone through as well. But we don't allow victims to do sentencing, and we don't allow juries. So this whole send a message thing, sure, I mean, it can happen. That's not our purpose. There's nothing in the rules of court that says, oh, and by the way, whatever you do, send a message and let everybody know, you know, that we're going to make an example of him. No, that is not, and that's not the kind of system in which under which I want to live.
Well, this gets at the issue in a somewhat different way. And I think it's important to mention, too, in getting all the key facts out. After Brock Turner was sentenced, there was an immediate hue and cry about Judge Persky, and did he sentence him too lightly? Did he let him get off too easily? And there was a process in California actually for investigating Judge Persky, and so it isn't just, I mean, your opinion counts for a lot, Judge, but there actually was a process that looked at whether Judge Persky violated any rules. Did he act improperly? Did he do something wrong as the judge? And it was found that he didn't do anything wrong.
Yeah. So
right?
This recall has nothing to do with a judge doing anything wrong or unlawful or abusing discretion. That's what makes this recall so unique. There have been 3 successful recalls of judges in California before this. And those judges either engaged in breaking the law, bribery, or such egregious behavior. So I'll give you an example. One judge charged tickets of the public to come into his courtroom to watch a murder trial. I mean, this stuff is just off the charts. Right. So this is the first time a judge with a 14-year record, impeccable record on the bench, was targeted for recall, having done nothing wrong at all. So the Commission on Judicial Performance is a governmental body in California that disciplines judges. And the commission got million complaints because the mastermind of the recall said, let's get a petition and get rid of this judge and complain about this judge to this commission. So this commission, because this was a very high-profile case, undertook a thorough investigation of all of the cases that the recall people were claiming where the judge had shown bias or engaged in misconduct. And anyone can read this report, and they should read it. I implore people to read it. And that commission said this judge did nothing wrong, did not abuse discretion, and has no history or pattern in his sentencing of bias or misconduct. But it didn't matter to the recall people at all.
Well, and that gets at the issue of what is a recall, because as you've said, many have said, you cannot like what happened here. You can have all kinds of views about whether our system as a whole, far beyond this particular individual judge, whether our system treats these crimes too harshly or too leniently. But we have a situation where the views people have about what happened here in this particular case were translated into a popular electoral issue. And that's really unusual. Now, not every state elects its judges. California is one. Pennsylvania, where we are right now, is another. Other states have judges appointed. Federal court judges are appointed through a constitutional process of nominating, and then the Senate giving its consent. Other elected officials can be recalled. They can be voted out for one thing, and that could have happened to Judge Persky. He could have come up for re-election and simply been voted out. But there are also mechanisms for removing an elected official from office, and we call that impeachment. This is something different. This isn't impeachment. And you started down this path in pointing out that Judge Persky didn't do anything wrong. You don't typically impeach a judge or a member of Congress or a president merely because you don't like them or you disagree with their vote on a particular issue or the policy that they may be putting forth on immigration or whatever it might be. You impeach a president or a member of Congress or a judge for a crime. But you can recall a judge in those states that have this process for no reason.
So there
right? And that
a couple of corrections. First of all, in California, most judges are appointed.
Okay.
So 95, maybe even 99% are appointed. So when I started, I was appointed by Jerry Brown, the governor. Every judge, and let's just talk about trial court judges in California, are appointed for a fixed term, and it's 6 years. So at the end of 6 years, the judge can decide, oh, I don't want to be a judge anymore and leave, or the judge can say, I want to stay here. If the judge is not opposed, then the judge is basically automatically elected in for another term. Or you can decide, oh, I want that seat. I want that judge to go, I will run against that judge, and then there is a campaign. All right, okay. So that's the first thing.
Okay.
People, and particularly in the recall, try to equate judges with politicians. Oh, well, they're all elected. Well, first of all, as I've said, we're not. Most of us are appointed.
More complicated.
But beside the point, what are politicians? Politicians are people who go out and campaign and promise people that they're going to do things for them. So if I'm elected to the city council, then I'm going to do this. I'm going to make sure that street gets paved, or I'm going to see that playground structure, a new one is put in. I make promises if I'm a politician, and then if I don't come through on them, well, people will throw me out when I come up for re-election. What do judges do? So the first time, whenever you become a judge, you take an oath of office. There's nothing in the oath that says, I swear or I affirm that I will do whatever public opinion tells me that I should do. Nothing in the oath. The oath says, I will uphold the law of the state of California and the laws of the United States, all right? So we are not politicians. And so people say, well, wait a minute, if you're not, you still should be held accountable to the people. Judges are held accountable in at least 3 ways. 1, you come up for re-election. If you don't like me, just don't like me, I haven't done anything wrong, you can run against me or find someone to run against me. Secondly, if I have abused my discretion, if I have broken the law, then the attorneys on either side are going to appeal, and I'm going to get reversed, and I'm going to be told, you were not good, you did something bad. Third, if I'm really bad, doing, not just breaking the law, if I'm just abusive to women, or if I'm not, treating with respect people of color in my courtroom, people complain, that's the Commission on Judicial Performance. There are several ways in which judges are held accountable. The recall in California is one that says, basically, and it's in Article 2 of the California Constitution, it doesn't set any criteria for what a judge must have done to be recalled. It's a free-for-all. I don't like what that judge did in that Brock Turner case. Get him out. Even though it's been cleared of any wrongdoing, the sentence was lawful, and in my view, absolutely appropriate. Absolutely. This was not a prison case. Doesn't matter. In California, it's a free-for-all. Somebody gets up one day, gets a bee in their bonnet. Oh, let's do this. There's this recall thing. Let's get these signatures, and they had to gather signatures.
And they did, a lot of them.
Right, and a third of them were deemed invalid, but there were sufficient, more than enough, to meet the criteria. But signature gathering. The signature gatherers are paid $1.50 per signature, and it costs over $300,000 for them to get these signatures. So they paid people. Signature gatherers didn't even know what they were doing. They were just like, sign this, sign it. If that's what we want to do, okay, so be it. But that's just the first step. So once it gets done, and it has to be somebody who is, relentless and really wants to get rid of this judge, which is what this person did, because, and I say this person, the mastermind, she was able to raise over $1 million to get rid of one judge for one lawful decision. So my concern is, should we be doing that? I mean, I don't have a problem with recalls if they're utilized for judges who've engaged in malfeasance, and it's been shown that they have, been engaging in wrongdoing while on the bench. But do we want a system that says, oh, I just, popular opinion, I don't like your lawful decision, so I'm going to get you and I'm going to, get everybody riled up by spinning a false narrative, which was helped along, unfortunately, by the media. That's what happened in California, and I think that that's just very, very troubling.
Well, I've said we will get into this, and I think we have to, because I know part of your motivation here is bigger than just your feelings about what happened in this particular case and what's happened to this particular judge. We've alluded to it a little bit, but I think we have to say something about the broader issues here, because as you point out, the issue of mandatory minimum, which is how the California legislature responded to this, now requiring a minimum of 3 years for the crimes in prison, somewhere out in the boonies where no one wants to see these folks anymore. And we have a problem in this country in our criminal justice system with mandatory minimums that have come up in other contexts, resulting in literally millions of people in our country sitting in prisons right now. How does this situation, the Brock Turner case and what happened with Aaron Persky and the response to it? Yes, it's a sexual assault case, but what does that tell us about the broader implications that I know you're deeply concerned about?
So the two words I haven't utilized in our discussion so far are judicial independence. So our fight against the recall was based on judicial independence. So Ruth Bader Ginsburg once said that judicial independence is a priceless constitutional gift. And if you look at how democracy is set up, we have the legislative branch, executive, and we have the judicial. And if one of those legs gets pulled out, we're in big trouble. Your democracy falters. And I believe that this recall and the fact that it succeeded has now begun the process of pulling that leg out from under an independent judiciary. So in the bigger picture in this country, we have Donald Trump, who is attacking federal judges and some state court judges left and right. You have Pennsylvania, where you have judges who ruled on a gerrymandering case, and you have a group, Republicans, who said, we don't like it. It wasn't an unlawful decision. It's like, no, we don't like it. Again, the popular opinion versus, did they do anything unlawful? Did they break a law or did they abuse discretion? No. So,
and you're talking about threatening to impeach the justices who voted against the gerrymandering of the congressional districts.
Right, and so there's this kind of message out there now that says, you judges have targets on your backs, meaning you should be targeted, by the way, if you're breaking the law and if you're engaging in abusing your discretion, but not when you're upholding the law and issuing a decision that somebody just doesn't like. So my concern is that this recall is sending a message, because whatever happens in California doesn't stay in California. It kind of goes across the country. And so the message is, just you can go after these judges because if they do something you don't like. So that's the message to voters, and who many of whom are uninformed about how the criminal justice system works and what judges are supposed to do. So what I heard on the recall in California was, well, they're elected officials and they need to be, accountable to us, and that's it. And it's like, no, that's not it. And people just didn't want to hear it because there was this whole emotional appeal. And I'm very, very worried that this recall is the start of something that is going to pick up, that more and more judges, if not being recalled, are going to be challenged just because they are saying something or made a ruling that someone didn't like. And that's very disconcerting.
And so I hear you that one principled concern is, which means that this is bigger than just Aaron Persky and the facts of this particular case, is a principled concern about the independence of judges in all kinds of situations, facing all kinds of decisions that judges have to face every day, and not feeling like they have to look over their shoulder at public opinion or how public opinion will be for or against a particular decision they make. But one of the concerns that I know you have, and I just want to explore a little bit, is In this case, the outrage, the public outrage, was over this allegedly lenient sentence for this particular crime, and Judge Persky exercising what he thought was his judicially independent assessment of all the factors that led to that sentence. But if you take that process and apply it to a different context, again, we mentioned this earlier, we have a lot of people serving in jails and prisons today for weed, for nonviolent crimes, for crimes that have them serving much longer sentences than Brock Turner served. So is there a concern that one of the things, perhaps the thing, that judges will be looking over their shoulders about is the situation where they want to exercise a certain kind of leniency, and not in a bad way, I'm not using that term in a negative way, about somebody who really doesn't deserve to serve a longer sentence. And that could lead to a lot more people serving a lot more time, crowding our prisons.
Right. I hesitate to use the word leniency. For me, it's punishment tempered by mercy. Mm-hmm. And some people deserve it and some people don't. I've sentenced people to life without the possibility of parole, and I did not temper it with mercy because the circumstances and the defendant didn't warrant it. So to get back to your question, so I have a prediction to make. And the prediction is this, that this recall was really fueled by women who are very angry at a criminal justice system in which they feel they have not been heard. I don't take issue with their concerns and their complaints. I take issue with anger because when you try to fix a system and do it in anger, you get a worse system. All right, so that's the first thing. So it is my belief that it isn't so much that cases involving drugs are going to get a lot of attention. I believe it's cases where women feel they're not being heard. And here's my prediction, that when any judge in California and beyond gets a sexual assault case, and it's a case that, hey, could merit some mercy, the punishment tempered by mercy, it's not going to happen. I'm just telling you, prediction is sexual assault cases, judges are going to be hyper vigilant and figure, I'm going to look over my shoulder, I don't want to lose my job, so I'm going to give a harsh sentence and I'm going to be good to go. Second, where else do women feel that they are perhaps unfairly being impacted? And that's in family courts. So I've heard them, complaints, and I served in family court. I know the system very well, where women feel that they're not being heard in terms of maybe restraining orders or custody cases. And my prediction is that judges in family court, they're going to start getting targeted. And unless they do what maybe women think they should do in making decisions on custody, and by the way, child custody cases, they are the hardest cases. I mean, there's some that are clear-cut. Don't get me wrong. They're just clear-cut. But when it's a choice between two adequate parents or two inadequate parents, it's really hard. Right. But my prediction is family court's going to get a real focus from folks who are fresh off of a recall. They're going to keep looking at sexual assault cases, and they're going to start now looking at where other courts where women are impacted, and my prediction is going to be family court. And that I find frightening. If judges are going to be looking around and seeing what father's rights group is sitting in the courtroom and, they're going to come after me if I don't make this decision versus that one, we're in big trouble. So, in big trouble meaning the independence of the judiciary is going to be more and more eroded. And then your democracy just starts to falter. State courts are more the target of this because federal judges are there for life.
Right. They're
not going anywhere. But the state courts are going to be, in my view, as a result of the recall, under attack. And for me, it's a very sad time to be a judge on the state courts, and it's a frightening time. And the judges who have the courage to say, you know what, I don't care who's out there yelling at me, I'm going to do what I believe is right. And that's who Judge Persky was. They're looking at probably, giving up their robes and, get to stepping, because that's not what the clamoring is all about. And so that is my concern, and why I'm speaking out as I am.
This case is not over. What I think people need to know what's going to happen from here. Tell us what you know about that, Judge.
Sure. Brock Turner has appellate attorneys, and it's his constitutional right to appeal. And just about everybody who's convicted of a crime, will file an appeal unless there is a plea bargain that says there will be no appeal. So his attorneys have already filed their opening appellate brief. The other side, that would be then the state, will file a response, and that will be, eventually go to a decision from the appellate court. The appellate attorneys are claiming there were errors in the trial, improper jury instructions, or maybe improper ruling on evidence, on witness testimony, and that's standard. That's what happens. The reason I keep, I'm kind of like, that's standard, is because the recall people utilize the fact that there was this appeal to say, to attack Brock Turner. See, he's not remorseful, he's appealed. Now, anyone who knows the law, criminal law, knows that that's ridiculous. Of course you appeal, and it's nothing to do with remorse. But that was, again, part of the false narrative that kept getting spun during the course of this campaign that really went for 2 years. From the time he was convicted, they started ramping up within a week. So it's just 2 years of this until finally it ended.
What about the recall itself? Is there? I've read that there can be some type of challenge to the vote, or is that now done? That's final and
As
over.
far as I know, this is a done deal.
Okay.
Judge Persky will lose his job very shortly. And interesting, in California on the ballot, when you have a recall of a judge, you can then, if you want to be a judge and replace him, you can have your name on the ballot. So there were 2 women whose names were on the ballot. So even if you vote no recall, you still have to vote for who should replace him if he is recalled. So one of those 2 women, and was almost by a landslide, like 70 to 30%, was picked to replace Judge Persky, and she was a supporter of the recall. So she gave money to the recall campaign, and the leader of the recall gave her money. So the question that comes up for me is, she will be sworn in, and she will swear to uphold the law. And again, there's nothing in the oath that says, I'm going to uphold whatever the people want me to do, although she supported a campaign that did just that, took that position. So how does one take an oath? And then what do you do on the bench? She's now sworn to uphold the law, but she also said, nope, I think he should have been recalled. Really? So we'll see. It'll be interesting.
Incredible. Judge, thank you so much for being on the program and going through this important story with us. It's fascinating, it's important, it's troubling in a lot of ways, and something we all have to pay pretty close attention to going forward.
Well, thank you for your thoughtful questions about this, because that's what I found lacking as we were, fighting this recall. Just thoughtful questions, some critical thinking about it, and that's clearly what you've done on this. So thank you.
Thank you so much.
My pleasure.